Thank you, Mr. Ravana. The, he says I have radical views. So I'll continue with that radicalism today, but it won't be rascality. I will start with protocols. I'm not so versed in protocols, so I'll simply start with ladies and gentlemen, as the Americans do. But I have before me the matriarch of the Nwosu, early Nwosu family. I recognize and I welcome you. You will now be the point of contact between us and the rest of the family. I recognize the Amanyanabo of Brass, the first governor of Rivers State. Having said all this, I say, ladies and gentlemen, my lords, spiritual and temporal, you are welcome. I will start with a personal experience. I was far away outside Nigeria. I had a chat with Lucius in the night, and he said my son was with him, and I was told they were together until 11 p.m. Then I don't know whether it was a vision. I was visited by Lucius in all white, hand gloves, trousers, socks, shirt, and then he was sort of waving. A few hours after that, because of the time zone, my son called that Lucius has passed on. I screamed, "What happened?" He said he was on his way to the house. Well, maybe, as Shakespeare would put it, brief candle. Maybe that's why I saw the candle and then, but it was gone. Now, today is the first memorial lecture in memory of the great man we are celebrating. I am reading from the iPad, the paper I presented. The hard copy in the brochure may not be complete. And like the woman who gave testimony in the church, I had an alternative, so I give honor and glory to God for that. So I'll draw your attention to pages 10 and 11. There's something missing there. Paul said, there was amongst us a distinguished gentleman. He had physically ceased to be with us today. Death snatched him away from us. He was an eminent legal luminary, hailing from Umbise clan of Imo State. He practiced law in the top brass from here in Porakot, the Federal Capital Territory, and he was a senator, a notable passionate in his own right. He was not physically a giant in the caliber of Goliath, but figuratively among lawyers, he was such a towering figure. He had a passion for philanthropy and was ever ready to help a friend and those in need. Like Mahatma Gandhi, he was a fellow-feeling character with lots of empathy, benevolence, and tender heart-heartedness. He cheerfully sought to assist and assisted his less privileged colleagues and others who were either sick or in their need. When an exuberant governor of Rivers State closed the courts, the high courts particularly, under the pretext of renovation, his ulterior purpose being actually to frustrate the filing of likely actions challenging his unpopular policies. Eli Nwosu, for short Eli, went out of his own to pay certain categories of junior lawyers stipends for several months. The governor's malady persisted. Beneath his not too large a physique, he had the compassion of an elephant with the heart of a lion. Turning his back at a fight was not his character. His advocacy was always bold and courageous, and he had a gift of humorous repartee, adorned with rustic folk proverbs to adumbrate on any issue. With these attributes, he ruled the jungle of jurisprudence and litigation, and like the fox, he outwitted several legal luminaries in courtroom advocacy. Was very wise in procedure. Very much have. For this, a story was told that the legendary Chief F.R.A. Williams, SAN, in a friendly banter after an argument in court, had jokingly retorted, "You are not Lucius, but Lucifer." A good lawyer is not necessarily the first-class law student, as I've always said in every forum I went. Rather, a good lawyer is that lawyer who, at any given moment, is abreast of the applicable rules of procedure and is so well knowledgeable and cognizant of either the provisions or principles of the law on the issue at hand. Lucius was not an all-roads legal practitioner. He selected his area of practice and specialized in it. His chosen area was generally environmental laws with more emphasis on oil and gas and related issues. His clients were largely communities ravaged by oil spillage, ranging from Mogoniland to Akwa Ibom, including also to Bayelsa. I never came across at any instance or occasion where and when Eli Nwosu, SAN, ever represented an oil company or oil major in an upstream sector against individuals or communities. He has disdain for political cases, particularly election and electoral jurisprudence. He once told me that there's a lot of uncertainty in that area, so he won't go there. Some observers of our subject, senior advocates, say he was brutally too frank to tolerate any shenaniganism of any accused person or on trial for committing criminal offenses. He made his remark predominantly in the field of oil and gas, if I may repeat, and related matters within the terrain of environmental laws. I'm coming. In June 1998, Eli Nwosu, then barely 15 years at the bar, had to file the case of Monokpo against Mobile Production Nigeria Unlimited and Mobile USA incorporated in USA, claiming against the two defendants jointly and severally a total sum of 5 billion naira on behalf of the two communities for ecological damages and injurious affection. There were two sets of plaintiffs, the suits having the same substratum against the same defendants were consolidated. Only the first defendant, the subsidiary of the second defendant, entered appearance and filed statement of defense. The second defendant neither entered appearance nor had filed any statement of defense at the time the plaintiffs closed their case. And the court witnesses, including professional valuers and experts on ecological matters. At the close of the plaintiff's case, the defendants, through their counsel, entered a no-case submission via the motion on notice. Thereupon, Eli, the counsel for the plaintiffs, filed a motion for judgment against the second defendant in default of pleadings, for judgment in default of pleadings and on the plaintiff's evidence, Both motions were argued together, and upon early concluding his arguments on the motions, particularly the motion for judgment, the defense sought and was granted adjournment to reply. On the adjourned day, the defense was absent, apparently in a dilatory tactic. He later filed motion for extension of time within which to file the statement of defense of the second defendant. The trial judge subsequently dismissed the no-case submission of the second defendant. Thereafter proceeded to entering judgment in favor of the plaintiffs. The defendants appealed, the Court of Appeal, finding no merit in their appeal, dismissed them. In the further appeal to the Supreme Court, Mobile Production Unlimited and Monoco 2003, legal LPELR 1886 SC, the Apex Court, after resolving most of the issues against the appellant, held that the failure or refusal of the trial court to consider the motion on notice for extension of time within which the second defendant will file a statement of defense amounted to denying him fair hearing, the right to which was his fundamental right under the Constitution. The Monoco case became a locus classicus. However, it raised some pertinent questions as well. The two courts below, having found that the defendants appellant were engaging themselves in dilatory tactics or time-wasting gimmicks, was the filing of the motion for extension of time to the second defendant to file his defense out of time, not itself an abuse of court process. I didn't answer the question. I just put it as a rhetorical. Would the Supreme Court not have resorted to his own general powers vested by Section 22 of the Supreme Court Act to assume jurisdiction over the whole proceeding as if the proceedings had been instituted and prosecuted in the Supreme Court at the court of first instance and rehear the case in whole or in part, or may remit to the court below for the purpose of such rehearing, or may give such directions as to the manner in which the court below shall deal with the case in accordance with the powers of the court. Similar powers are vested in the Supreme Court by Order 8, Rule 12 of the Supreme Court Rules. Since delay defeats equity, and equity does not assist the indolent, and in this case, the party choosing altruistic and mischievous indolence, the Supreme Court should have, in its wide discretion, considered the exercising the powers vested in it by Section 22 of his enabling act and Order 8, Rule 12 of their rules. The Monoco case, to the credit of the young advocate, then gave the Supreme Court anxious moments. Most of the justices of the appeal panel had each subsequently congratulated him. And most of them, in fact, this was a case that assisted him in no small way when he applied for the SIP. More take-home from Monoco case includes the incisive and expensive investigations undertaken by LE prior to his filing the suit to establish the links and nexus between Mobile Production Nigeria Unlimited and the overseas parent company, Mobile Incorporated of USA. Similarly, he committed handsome expenditure to get experts and professional valuers to undertake the field assessment of the ecological damages for the purpose of their subsequent evidence. He did the same thing in Osaro case and several others. Several other oil and gas matters from Akwa Ibom and Osaro, and much to his credit, victory was his own. This, in salute to his astute enterprise, had become his proclivity in all similar cases. He was a child soldier in the Biafra army. He must have acquired the spirit of nulla deditio, Latinism for always be ready, diligent, and vigilant. From the slogan of the Biafran army, the prize of liberty is external vigilance. With apologies to the Amananyambo, who fought on the side of the federal troops. The enterprise and the contributions to the body of environmental laws and jurisprudence did not go unnoticed. The Supreme Court, acknowledging Early's enormous work and huge contributions to environmental laws and jurisprudence invited him and other jurists as amici curiae in the Center for Oil Pollution against NMPC. Citation is provided. His contributions assisted the court in deciding inter alia that the rights to life, as well as clean water, clean environment, air, water, land, and forest, being rights guaranteed by the Constitution of the Federal Republic of Nigeria, an African Charter on Peoples and Human Rights Ratification and Enforcement Act for the Development and Safeguard of Human Communities, versus local standing on either an individual or the community, and even a non-governmental organization, NGO, to challenge any nuisance by way of pollution or seepage into the river, stream, or underground water, providing the community a source of livelihood and drinking water. The Apex Court had earlier in Fawemi against the governor, Lagos State, Fawemi against Akilu, held that every Nigerian, being his brother's keeper, had a standing in law to enforce penal laws where a crime had been committed. The Center for Oil Pollution case was a major development, not only in the body of environmental laws, but also in the area of the vexed issue of local standing. It liberalized the law on local standing. Shell Petroleum Development Company of Nigeria, SPDC, had been a major player in oil and gas exploration in Nigeria, particularly in the Niger Delta area. By way of just chipping in, his battles with Niger Delta, battles with oil and gas must have started from when Shell unceremoniously disengaged his father as an employee. The company had entered into lease agreements with the communities that held customary rights of occupancy over parcels of land for purposes of their business. In SPDC against Amadi and others, 2011, I wrote the lead. The SPDC, while remaining as a tenant of a Okoro community or family, had subsequently, albeit surreptitiously, obtained a statutory right of occupancy wherein the customary right of occupancy of their landlords were purportedly extinguished in favor of the SPDC, who now, armed with a statutory right of occupancy, was no longer obligated to pay agreed rents to their landlords. Early briefed by the customary landowners, undertook a thorough pre-litigation forensic investigations that exposed the fact of SPDC having surreptitiously obtained the offensive statutory right of occupancy. He took out forfeiture proceedings against the SPDC, which resulted in both the orders of forfeiture against SPDC and the nullification of the statutory right of occupancy. A Japanese auto manufacturer had this advert: good thinking, good products. That, to me, is a summary of the life and law practice of Lucius Eze Akamadu Nwosu. Amazed by how the maverick early achieved his feats in litigation, junior lawyers nicknamed Ekwensu, which I'm told in Igbo means wizard. I used to buy for my children in those days a novel titled The Wizard of the Law, the author of which I no longer remember. The novel told the story of a brilliant, astute, and resourceful lawyer. It was the Nigerian equivalent of the American Perry Mason series created by Stanley Gardner, which in no small way nudged me to reading law. I'm sure the junior lawyers, unlike the FRA William SAN, who jocularly christened Lucius as Lucifer, decided to nickname Eli Nwosu Ekwensu, having in their formative years read The Wizard of the Law and having in their early days seen their mentor in real life practice of wizardry of law in Eli Nwosu. It is good to be good at all times. Lucius was in his lifetime good in all his endeavors. Let me conclude this discourse stating, as John Wesley would say, that early Nwosu did his best in all, did his best he could in all the ways he could, and at all the times he could, in all the places he could, to all the people he could, and more by all the means he could. I remember my 2 terms tenure here in Port. For every Easter, for every Christmas, he brought truckloads of rice to give to the staff of the Court of Appeal. And I'm told also he repeated the same in all the courts, particularly the federal courts. Using all the parameters at my disposal, particularly Jeremy Benton's felicitous calculus, Lucius Nwosu was a good man, a very literate and learned gentleman, a quintessential jurist, a shrewd and astute advocate, and a philanthropist par excellence. The body of this enigmatic Lucius Nwosu may lie molten in the grave, but he still lives eternally with us. And to him I say shalom. Thank you very much.
Thank you, thank you. Well, we've had the lead presentation by my Lord Honorable Justice Ajembi Echo. And of course, the summary of which is that Lucius was really a diligent lawyer who majored in environmental cases and issues and disputes. He was also a very thoroughbred lawyer who would prepare his brief very well, and he was also very large at heart. So he combined the knowledge of law with his personal gift of reaching out to everyone that come across him. So may I now invite the next panelist and our people that, with the permission of the chairman, you have, yeah, maybe, okay, I understand you sit down there. We'll bring the mic to you. To be very brief, you have about 15 minutes each. The day is far spent. The first person to make his contribution will be Tuduru Ede. He doesn't need much introduction. He's part of you here. He has served as the chairman of Ahoada branch and now the managing partner of Turudu Ede & Co. He is also an environmentalist. So please, you have 15 minutes to make your contribution. The floor. Yeah, you can sit there. You can just sit there. You can also sit here. Yes.
Lucius Nwosu, SAN, where does one start from? Better sometimes to start his contributions from the law reports. Like the learned law lord had just summarized in the lecture, each time he did any cases from what we have read from the law reports, he was usually over-prepared. Because from a discussion I listened into where he participated, he was usually of the opinion that the persons against whom you are litigating themselves have everything going for them. They have the experts, They have the resources to retain some of the best lawyers you could brief. So, and the communities were at the receiving end. But he had to take the fight to them. One, through the advocacy in the courtrooms of Lucius Nwosu, SAN, he compelled the oil companies to